尊敬的各位与会嘉宾，联合研究中心的各位同事们，大家好，我是清华大学法学院的龙俊，非常荣幸能够代表清华大学法学院致辞。清华大学和西南威尔士大学于2019年联合成立了本研究中心，旨在共同推进国际经济法和国际商法领域的学术研究，共同培养高水平国际商法和国际经济法人才。这些年里，我们就技术监管法律问题、国际商法与经济法的走势等议题开展了深入的学术讨论，取得了巨大的影响力。感谢西南威尔士大学和清华大学各位亲爱的同事们。在全球对抗新冠疫情的大背景下，重新思考中国政策和法律途径，以确保可持续有弹性的复苏，比以往任何时候都更加重要。今年的会议汇聚了清华大学法学院和西南威尔士大学的专家学者，以中国在经济发展过程中所面临的前沿重点问题为出发点，旨在从国际贸易法、国际投资法、银行与金融法、知识产权法、公司法、竞争法、环境法和争端解决等多角度进行共同探讨。与今年的主题相关，清华大学参加会议的老师们大都参与了中国的法律或者政策的制定工作。例如，邓矮峰教授参与了环境相关法律政策的制定工作，张成颖教授参加了反垄断法的修订工作，崔国斌教授在最高人民法院兼职研究员，汤新教授曾在证监会担任中国证券监督管理委员会第1、第2届并购重组审核委员会委员，高思敏教授正在参与破产法的修订，沈朝晖教授正在参与公司法的修订等等。我们知道，西南威尔士大学的 Deborah 教授、周维欢教授、樊坤教授、白雪教授等都是全球知名专家，对于政策和法律的关系一定能够提出独到且富有启发意义的观点。我期待着大家今年精彩的讨论。最后，预祝本次会议圆满成功。
Ladies and gentlemen, distinguished guests, dear colleagues from Tsinghua UNSW Joint Research Center for International Commercial and Economic Law, greetings to you all. I'm Long Jun from Tsinghua University School of Law, and it is my great honor to address you on behalf of the school. In 2019, Tsinghua University and University of New South Wales jointly established our research center, aiming to advance academic research and foster high-level talents in the fields of international economic law and international commercial law. Over the years, we have engaged in profound academic discussions on topics such as legal issues in technological regulation and trends in international commercial law and economic law, achieving significant impacts. I extend my heartfelt gratitude to our dear colleagues from the University of New South Wales and Tsinghua University for their invaluable contributions. Amid the ongoing efforts to combat COVID-19 worldwide, it is more crucial than ever to consider the development of China's policy and regulatory approaches to ensure a sustainable, resilient recovery. This year's conference brings researchers from Tsinghua Law School and UNSW Law and Justice together to discuss the policy and the regulatory development in a wide range of fields, including international trade law, international investment law, banking and finance law, intellectual property law, corporate law, competition law, environmental law, and dispute resolution, focusing on cutting-edge issues faced by China in building back better. Aligned with this year's theme, it is noteworthy that the majority of our esteemed faculty from Tsinghua University actively participated in the formulation of Chinese laws and policies. For instance, Professor Deng Haifeng contributed to the formulation of environmental-related legal policies. Professor Zhang Chenying participated in the revision of anti-monopoly laws. Professor Cui Guobin serves as a part-time researcher at the Supreme People's Court of China. Professor Tang Xin previously served as a member of the Mergers and Acquisitions Review Committee of the China Securities Regulatory Commission in the first and second sessions. Professor Gao Simin is currently involved in the revision of bankruptcy law, and Professor Shen Zhaohui is participating in the revision of corporate law. Moreover, we are honored to host distinguished global experts from the University of New South Wales, including Professor Deborah Healey, Professor Zhou Weihuan, and Professor Fan Kun, and Dr. Bai Xue, whose exceptional perspectives promise to enrich our discussions with profound insights into the relationship between policies and laws. I look forward to the stimulating discussion this year. Finally, I wish this conference a great success. Thank you.
Dear friends and colleagues, my name is Weihuan Zhou. I'm an associate professor at the Faculty of Law and Justice, UNSW Sydney. It is a great honor and pleasure to be here today. As I said to Professor Long, this is also the first in-person event for CICEL. And we're looking forward to a great event with Tsinghua University Law School. In giving the opening remarks, I'm actually giving the remarks on behalf of our Associate Dean International and UNSW Law and Justice, Professor Christine Forster. Unfortunately, she won't be able to join us today, but she did ask me to pass a few words on her behalf. So what I'm going to say in the following is the words that I was given by Professor Christine Forster, our Associate Dean International from UNSW Law and Justice. It is a great honor to speak on behalf of UNSW Law and Justice. We value greatly our relationship with Tsinghua Law School and Tsinghua University. The Tsinghua UNSW Joint Research Center for International Commercial and Economic Law, JCICEL, was established in 2019 between Tsinghua University Law School and UNSW Law and Justice. The Joint Center aims to promote research in the areas of international economic and commercial law and to develop future leaders in these fields. Over the past few years, the Joint Center has hosted a number of academic forums that have generated new conversations in this important area of law. The theme of building back better China's policy and legal approaches and global implications, which is the theme for this year's joint event, is very timely, given the pandemic providing an opportunity to together discuss the development of China's policy and regulatory approaches to ensure a sustainable, resilient recovery. The aim of this conference to bring researchers from Tsinghua Law School and UNSW Law and Justice together to discuss those policy and regulatory developments is very valuable. The conference papers looks extremely relevant and interesting, encompassing a wide range of fields, including international trade law, international investment law, banking and finance law, intellectual property law, corporate law, competition law, environmental law, and dispute resolution. On behalf of our Professor Forster, she hopes that we have an engaging discussion on these topics and together forges new possibilities and ideas towards a common path for global development. And she sent her best wishes for this conference, but also very importantly, for our collaboration. And finally, and it's also my wish that we will have a very successful and invigorating conference. Yeah. Perhaps we can move to the first session. Yeah. Deborah Healey. Yeah. Without further ado, I think we can move on to the first session, which will be chaired by my colleague, Professor Deborah Healey, who is a professor at the UNSW Law and Justice, and also my co-director of the China International Business and Economic Law Center. Professor Healey, the floor is yours.
Hello, everyone from Sydney. I am sorry that I cannot be there to share this important event with you all, but I'm hoping to be able to learn a lot by chairing this session and listening to the other sessions. I would like to open session 1, which is entitled Recent Developments in China's Approach to Global Economic Governance. And we have 3 speakers in this session, all of whom are known to you and all of whom have a CV appended to the program. So I won't go through their full CVs except to name them briefly as we start. What I intend to do is have each of the speakers speak for around 20 minutes. And then at the end of the session, people can address questions to them, which they may have the opportunity to answer, and I will chair that question and answer session. So if that's acceptable to everyone, I will introduce the first speaker. And the first speaker is Professor Zhang Chenying, Director, Center for Competition Law, Tsinghua University Law School, who is a noted competition lawyer and who will speak on China's approaches to cross-border data flow, a very important issue in the current economic environment. So please, Professor Zhang Chenying, you have 20 minutes, around 20 minutes to speak. Thank you.
Thank you, Professor Healey. My dear friends, I'm so honored to have this opportunity to share my idea about China's approaches to cross-border data flow. And in today's, I will emphasize on 3 points. The first one is the fundamental concerns in global regulations of cross-border data flows. I will compare China, EU, and US concerns toward this area. The second one is China's basic principles for cross-border data flow regulation. And the last one, exploring the compatibility from the digital economy area. Digitization has driven a new wave of global economic integration. Cross-border data flows and the digital trade have grown significantly, gradually becoming the very new energy for global economic development. Research indicates that in 2014, cross-border data flows contribute $2.8 trillion to global economic growth, and it is projected to reach 11 trillion by 2025. In this context, discussions about cross-border data flows have increasingly shifted towards the realm of e-commerce and digital trade. In February 2016, the Trans-Pacific Partnership, that is TPP, was signed, becoming the first trade agreement to include binding rules on the cross-border flow of data. In January 2019, after more than a year of consultation, 76 members of the World Trade Organization and WTO member, including China, formally signed the joint statement of electronic commerce, launching plurilateral negotiations on e-commerce, in which cross-border flow of data is one of the important issues. At the same time, region or bilateral trade agreements have also begun to provide for the cross-border flow of data. And some of them have basically borrowed the provision of the CPTPP. For example, the Digital Economic Partnership Agreement signed by Singapore, New Zealand, and Chile in 2020. In reality, cross-border data flow not only involve economic issues such as cross-border trade, but also encompass the concerns related to privacy protection, national security, jurisdiction, and other non-economic considerations. Currently, there are significant differences among countries in their understanding and positions on these issues. Trade agreements that predominantly focus on the economic aspect and unable to bear the weight of consensus binding. This not only result in the inability to reach many trade agreements, but also inactivates the fragmentation trend in global digital governance. Currently, there are significant differences among countries in their understanding and the positions on these issues. Trade agreements that predominantly focus on the economic aspect are unable to bear the weight. It is not only result in the inability to reach many trade agreements, but also exacerbates the fragment trade in global digital governance. China recognized early in the limitation of solely discussing cross-border data flows from the trade perspective. In 2019, in the initial proposal of the WTO e-commerce negotiations, China emphasized the need to define e-commerce as cross-border trade in goods conducted via the internet, along with related payment and logistics services. Recognizing the complexity and the sensitivity of issues related to cross-border data flows, China advocated for further discussions. Based on this comprehensive understanding, China has introduced a new concept and a paradigm of secure and orderly cross-border data flows. It launches the Global Data Security Initiative and actively explored the establishment of a regulatory system for outbound data flows. Particularly in recent years, China has enacted the cybersecurity law, data security law, and the personal information protection law, establishing a comprehensive framework for managing the outbound flow of data. This framework employs a dual-track control model, focusing on critical data and personal information. It means that two different ways to protect this kind of data. Currently, the relevant supporting regulation for the mentioned laws are gradually being perfected. Especially in recent times, several measures have been introduced, including the measure for security assessment of cross-border data transfer, the announcement on the implementation of personal information protection certification, and the methods of standard contract of cross-border personal information transfer. Additionally, drafts for significant complementary regulations like the regulation on network data security management have been released for public consultation. The second part is about the fundamental concerns in global regulation of cross-border data flows. Currently, the governance of cross-border data flow has not yet been treated as a standalone global issue. Discussions are often released under digital trade negotiations. However, according to the definitions from the OECD, WTO, and the International Monetary Fund, digital trade refers to trade orders and/or delivers conducted digitally. This definition notably does not encompass cross-border data flows unrelated to specific goods or services transactions. This implies that regulating cross-border data flows should not be limited to trade rules alone, but should address the flows of data themselves. Considering the nature of data as carriers of information, they can contain a wide variety of information from various aspects of human society. As a result, cross-border data flows involve personal information, commercial data, public data, and even data related to national security. This duality presents both economic dimensions that promote trade and a series of non-economic challenges. To address these challenges, the legitimate concerns of major economics in regulating cross-border data flows mainly encompass three aspects: the protection of personal information rights. Second one is prevention of national security risks. And the last is requirements for judicial enforcement jurisdiction. So I will emphasize each of these. First, the protection of personal information rights. The protection of personal information has been the earliest concern in regulating cross-border data flows and remains relevant today. The EU has legislated comprehensively in this area and extensively discussing the best ways to promote the trade through cross-border data flow while safeguarding personal data protection. In 2018, the EU Commission ultimately approved the European Union's adequacy decision on cross-border data flows and personal data protection clause. The EU's stance is closely tied to its historical consideration of personal data protection as a fundamental right and its dedication of enforcing rigorous high standard in this area. The EU's perspective revolves around the notion and the personal data originating within its border should only be allowed to flow to countries or regions that uphold an equivalent level of protection. In 1995, the EU enacted Directive 9546 EC, Article 25 of which mandated that personal data could only be transferred to countries deemed by the EU to provide an equivalent level of protection. This provision was reiterated in Article 45 of the General Data Protection Regulation, means GDPR, which came into effect in 2018. As of now, only 14 countries or regions have been granted an adequacy decision by the EU. According to the GDPR, transferring personal data to countries or regions without an adequacy decision can be accomplished through two main approaches. Number one, appropriate safeguards, means data controllers or processors can offer appropriate safeguards, including binding corporate rules that are legally binding and permit transfers with companies. Standard control clause approved by EU for intercompany transfer and EU approached certification mechanisms. The second one is the organizations under special circumstances, explicit consent necessity for contract and the protection of vital public interest. For the perspective of the WTO negotiation text, the United States personnel is to some extent based on this leading role in formulating Article 14.8 of the Comprehensive and Progressive Agreement for CPTPP related to personal information protection. The EU stance originates from its value of a free market economy. It does not consider personal information or privacy as a fundamental right, but rather includes it within the realm of consumer protection in the market economy. At the federal level, the US lacks means have no unified legislation for personal information protection. Instead, the Federal Trade Commission, FTC, ensures that consumers have the right to be informed and give consent regarding their data usage. Recognizing the risk of market failure, specialized legislation has been introduced for special sectors such as the credit reporting industry and health insurance sector. This market-driven and risk-based approach helps explain why the US possesses that limitation on cross-border data flow of personal information should be necessary and proportionate to risk involved. The US is essentially opposed a universal adoption of high standards for personal data protection as seen in the EU's approach. Instead, the US advocates for countries to protect personal information in their own ways, fostering compatibility among different approaches. The second part is towards the prevention of national security. After the Snowden revelation in 2013, which exclude the programs like PRISM, countries increasingly began to recognize the national security risks associated with cross-border data flows. In response to these concerns, some countries started imposing restrictions or prohibitions on certain data transfer across borders. This extended beyond personal information to encompass non-personal information in sensitive sectors such as finance and healthcare. It's worth noting that despite the US advocating for completely free cross-border data flows and the EU opposing data localization, both have enacted legislation domestically that restricts cross-border data flow based on national security consideration. These regulations are by no means limited to exception clause. For instance, in the case of United States, since 2010, it has established the controlled unclassified information program, means UCI program, which controls sensitive information in 20 major categories and 125 subcategories outside of national security, including defenses, finance, intelligence, law enforcement, and etc., with a varying degree of control based on risks. In August 2018, the Foreign Investment Risk Review Modernization Act was enacted, authorizing the Committee on Foreign Investment in the United States to review non-controlling foreign investment in US businesses involving sensitive personal data to prevent such data from being accessed by foreign governments or entities. During the Trump administration in May 2019, an accurate order was issued titled Securing the Information and the Communication Technology and the Services Supply Chain, which prohibited transaction and the use of information technology and services that posed a threat to national security, foreign policy, and economic interest. In June 2021, during the Biden administration, an executive order titled Protection Americans' Sensitive Data from Foreign Adversaries was signed, aimed at preventing sensitive data related to the United States national security from being compromised by foreign adversaries. Besides of this, the three main concerns about the cross-border data flows, actually here are blocking provisions and the storage of in the domestic servers and so on. And my last part is about the China's basic principles of cross-border data flow regulation. And so I will give a short conclusion about my speech. The institutional compatibility between the jurisdictions is mainly based on the conclusion of a bilateral or multilateral mutual legal assistance agreement on the premise of mutual respect for countries. However, traditional legal assistance procedures, which need to be held through communications between the specialized authorities of both parties, are often complex, lengthy, and inefficiency, and have become increasingly unsuited to the development of the global digital economy and the need of rapid dispute resolution. So, in a word, means to ensure this right to data access legal responsibility for entities that failed to provide data promptly can be defined. By doing so, the need for data localization promptly by judicial issues can be significantly reduced. It is recommended that China explore the establishment of such a data access right model in bilateral or multilateral judicial assistance agreement with other countries. So thank you for your listening. Let's move to
Thank you very much, Chenying, for your really interesting presentation, and I'm very sorry that I had to cut you off. I hope that we will be able to ask you some questions in the question and answer session which follows. I now turn to the second presenter, who is my colleague, Associate Professor Kun Fan, who is a member of the Siebel Center at UNSW Law and Justice. And she is going to talk about China's informalism in dispute resolution in the Belt and Road Initiative. Thank you, Professor Fan.
Good morning, ladies and gentlemen. Thank you so much, Deb. I wanted to start by thanking our colleagues from Tsinghua University Law School and my colleagues at Siebel for jointly hosting this event. It's a great honor and pleasure for me to present at the conference of our joint
It's a great honor and pleasure for me to. So today I will present a work in progress arising out of a research project
on the Belt and Road Initiative, a new model of economic order, which is a project I collaborate with a few colleagues at UNSW and is funded by the Australian Research Council. So our project intends to examine how the BRI is affecting the way that cross-border economic interactions are governed, and also explore the implications of these changes for the world economy. In today's talk, I will focus on one aspect of this research, which is China's reliance on informalism in the resolution of BRI disputes. So I'll start by presenting the dispute tree model and the concept of informalism, and then focus on the sub-branch of informalism to show pieces of evidence on China's reliance on the soft form of dispute resolution in the BRI, and finally go down the rules, trying to analyze the reasons for such preference. So I'll start by presenting the concept. The contemporary legal theory on informal justice tend to take on board this extension of power beyond the state. The Chinese informalism, on the other hand, is paradoxically state-led. In the Chinese informalism, instead of being an alternative to the court, the informalist approach has been historically and continue to be an essential and integral part of the dispute resolution system. So the Chinese informalism challenges conceptual opposition of informalism, non-law, civil society or interests on the one hand, formalism, law, state power, and rights on the other. The actual picture is much more complex and nuanced. The informalism is developed not in isolation, but hand in hand with formalism. So we can see on the one hand, Chinese dispute resolution approach is featured by informalism, deproceduralization, flexibility, more concerned with relationship and interest than the rights and legal commitment. On the other hand, we also see China recently appeared to be taking a more legalized and institutionalized approach towards dispute resolution, not only by furthering participation in the established existing dispute resolution mechanisms, but also by building its own parallel institutions, such as the International Commercial Dispute Prevention and Settlement Organization. So the Chinese model may represent a polycentric form of ordering, which can coexist. So I would like to use this metaphor of dispute tree to illustrate this blending of legal order in China that's adapted from the model of Aubusson, Edelman, and Milligan's dispute tree. Instead of narrowing the dispute to a single point at the top, as the pyramid model suggests, the dispute tree has many branches from a central trunk, as you can see from this illustration. Different branches represent the different paths towards dispute resolution, which also capture the living and evolving nature of disputes. So in this dispute tree, in China, we have this arbitration branch, which can include institutional arbitration, some foreign arbitration institutions like ICC, ICSID, London Court of Arbitration, Chinese arbitration like CITEC, Beijing Arbitration Commission, or ad hoc arbitration, which play an essential role in the resolution of cross-border disputes. Then you have the formal judicial branch, which can include, in the BRI context, either the Chinese court, the court of hosting state, or a competent court from a third country. And yet, which I will focus on, is the branch of informalism, which have been presented in different forms: negotiation, high-level talks, mediation, and other forms of settlement discussions. The informalism branch are deeply rooted and continue to play a strong support of the growth of the tree. The dispute tree model allows us to then explore how disputing parties interact with the tree, which branches they tend to choose in order to get the fruit and the flowers. So here the flowers represent the symbolic indica of justice, like recognition of legal rights or responsibility. And the fruit, by contrast, represent the actual interest, usually in the form of financial compensation, but it can be also future business opportunities. Now, having established
the dispute tree model, the next question is then how, right? How do parties choose the different branches in their contract? And when dispute arise, which branches they tend to choose in order to get the fruit and flowers? So I will now show the pieces of evidence on the reliance on the informalism branch, which have its sub-branches such as negotiation, friendly consultation, high-level talks that can be done directly between parties, sometimes facilitated by local partners or government, or the form of mediation facilitated by a third-party mediator. So let's first look at the BRI contracts. Underneath the BRI primary agreement signed between the government, usually in the form of memorandum of understanding, BRI also includes a complex web of secondary agreements or hybrid contracts involving private entities, state-owned enterprises, and government entities. And that have at least two categories. One category is a performance agreements, which can include performance guarantees, economic stabilization contract, concession agreements. The other category is a financing agreement, usually including loan agreement or grant agreements. So with JCICEL, we have reviewed a number of investor-state project contracts, so usually those performance agreements signed along the BRI between Chinese investors, the majority are SOEs, and the hosting state across Asia, Europe, Africa, and South America. So this is our finding from those reviewing of hybrid contracts. So our data is relatively small, given the confidential nature of those contracts. But in 14 out of 22 contracts that we have found where full dispute resolution clauses are available, they all require the parties to first attempt to settle the dispute amicably, often through negotiation within the time limit of 60 to 90 days. And if the party couldn't settle the dispute, then they could resort this matter to arbitration. In some contracts, there is also express reference to mediation or conciliation. So for instance, in the contract with a Guinea company, it referred to ICC mediation followed by ICC arbitration. What about the financing agreement? According to the research by China African Research Institute, which they reviewed a number of China-African loan agreements, it shows that most of those loan agreements also state that disputes should first be resolved by friendly consultation, and should that fail, then they can submit the matter to arbitration. In the actual practice, when things go wrong, how do parties resolve their disputes? So empirical evidence shows that despite the presence of arbitration clauses, Chinese entities going abroad do not primarily rely on arbitration to resolve their dispute, but instead heavily rely on negotiation or consultation with local governments and other stakeholders. So for instance, based on the number of interviews, that's the chart on the left side, that's the research conducted by the International Institute for Environment and Development in 2016. Negotiation emerged as a primary approach to political risk management, followed by arbitration and commercial insurance. On the right hand, this chart shows a survey done by the Beijing Arbitration Commission with Chinese enterprises with experience in the BRI projects, mostly construction projects, which also shows that negotiation and high-level talks are the most commonly used method of dispute resolution, followed by commercial arbitration and commercial mediation. In a more recent survey by CITEC, ongoing global of Chinese enterprises, they found that 70% of those enterprises do include arbitration clauses in the foreign-related contracts. But when disputes arise in those going global process, well, enterprises do often resort this matter to arbitration. But in the meantime, it also shows a significant number of enterprises have attempted settlement, which includes private negotiation facilitated by local partners, state-to-state negotiations through diplomatic channels, and also mediation. For those cases that went to arbitration, 45% reached a settlement. The percentage of settlement is even higher for those cases with a bigger amount in dispute. So that also shows even after they initiate a formal proceeding, parties still attempt to find opportunities to reach a settlement. What about public records? Despite China's recent emergence as a major source of outbound investment, we haven't yet seen a significant number of investor-state arbitration, at least compared to the counterparts in Europe or North America. So according to public records, there are a total of 18 cases where Chinese investor appeared as a claimant, 2 of which discontinued pursuant to the parties' agreement. Out of the 9 ICS cases filed against China, 3 discontinued with the parties' agreements. So for the interest of time, I'm not going into details with the case, but the public records, and there were also available cases that showing some use of conciliation or mediation. So here are a few cases that, based on public record, the parties have resorted either to consultation or conciliation, or they settled after initiating a formal arbitration. So that also shows those different branches are often intermingled, right? So it's common for parties to jump from one branch to another. Sometimes initiating arbitration might just be a strategy to continue or even start settlement discussions. Now, having said the different forms of informalism, the next question then is why? Why do Chinese enterprises prefer to use informalist approach to resolve their dispute when things go wrong? And why do Chinese state back the use of informalist approach for the resolution of BRI disputes? To answer those questions, then we need to go down to the roots. And I will attempt to explain this from 3 different aspects. First is the cultural fit with the relational mode of association in China. Professor Fei Xiaotong defined the Chinese society, historical and contemporary, as a differential mode of association, as contrasted to the Western organizational mode of association. So the Chinese pattern of social organization is like the circles that appear on the surface of lake when you throw a rock in it. Everyone stands at the center of the circles, produced by his or her own social influence. And everyone's circles are also interrelated. So our social relationship, like this picture shows, spread out gradually, individual by individual, resulting in an accumulation of personal connections. Within such a social relational structure, our web of guanxi is important not only for social, but also for economic reasons. So in this context of BRI, for Chinese investors, maintaining a good relationship with local government may be more important than forcefully pursuing their legal rights. And this is particularly so because a large number of the initial BRI projects are focused on infrastructure projects, which tend to be large scale, capital intensive, and with long development timelines. So in those situations, the preferred option to resolve a dispute is to engage in the intensive consultation and amicable talks in order to get the fruit, or at least some of the fruit, right? If that symbolizes the actual interest of maintaining relationship and maybe future business opportunities, instead of getting this flower, like recognition of their legal rights. Such preference is also influenced by important social economic considerations. In practical terms, this arbitration branch may lead you to the flower, a symbolic victory, but not the fruit, the actual financial compensation. So even if you win an arbitration, it may be difficult to enforce a award against the state assets in case of sovereign debt default. So we have not seen indeed any cases where the China Export Bank have used court or arbitration for sovereign loan defaults. In the past, they have agreed to a renegotiation of the loan terms and payment dates. Other cases, we've seen an agreement about the balance of payment problems or borrower invitation to third-party financiers to take over some of the debts at more preferential commercial conditions. So the prospect from the Chinese bank's perspective of getting a repayment, some of the fruits through refinancing, rescheduling, or investor equity injection would be far better than pursuing a formal arbitration with a reward that they can enforce. Furthermore, many BRI countries fall far below the global average of the Global Justice Project Rule of Law Index. So when investing in developing countries along the BRI, the Chinese enterprises often do not deem law-based strategies in general to be promising due to the lack of trust of legal system of the hosting country. So instead of relying on laws or formal channels, they tend to, especially the companies operating in Africa and other developing countries along the BRI, mostly rely on the connections and relationship with local stakeholders when problems arise. Lastly, the BRI project have been driven predominantly by Chinese state-owned banks and state-owned enterprises. So the state-driven character of Chinese investment in the BRI means that the metrics for Chinese investor is not purely project-based or the legal rights in this particular trade, but about the broader interest of the forest, right? So the interest engaged by China in designing and implementing the BRI projects overall. So reliance on investors' legal rights for one project, even if the case is decided in favor of Chinese party, may still be too costly a victory. So the fruits, compensation for one project, may not be worth it compared to the cost of losing the forest, if that symbolizes undermining the economic and long-term interest supporting the broader BRI. So the informalism approach with the interest-based attitude and search for a flexible and amicable resolution is in line with the BRI's philosophy of building a community of shared future and a win-win cooperative framework, and also the principle of extensive consultation, joint efforts, and shared benefits. So to conclude, I illustrated that the informalism branch provide essential support for the development of dispute trade in the BRI context. Of course, it is developed hand in hand with also formalism branch, like arbitration and formal judicial process. And I attempted to illustrate the cultural and social economic rules that may explain the choice of informalism branch. This trend is indeed in line with the natural evolution of dispute resolution. If we look at the way dispute resolution evolved over time, it's always in the constant rotation between formalism and informalism. We always start from informalism before courts even exist. Parties resolve their dispute informally. And then you need more predictability, so more rules has been introduced, it's getting more formalized, institutionalized, until it's become too expensive, too cumbersome, and that's when users start to search for informalism, right? So that's really perfectly in line with the circle. And it's also in line with the general trend, the development from in the investment law that moved from a power base to a rights base. And now the scholar have been argued that we should be moving to an interest-based approach. Again, this Chinese informalism is in line with that evolution. So I think I better stop here, and I look forward to further discussions and questions. Thank you.
Thank you very much, Kun, for your interesting discussion on that. I particularly like your tree. It's a very nice analogy. The next speaker is Dr. Lu Wang, who is a member of the JCICEL Center at UNSW Law and Justice, and she is going to be speaking about China's approach to investor-state dispute settlement reform, opportunities and challenges. So thank you, Dr. Wang, who is speaking to us from the US.
Thank you very much, Deb. Can everyone hear me okay? All right, good morning, everyone. Greetings from Washington, D.C. I would like to start by expressing my sincere gratitude to colleagues from both Tsinghua and JCICEL for organizing this remarkable joint conference. And it's an honor to be speaking with other esteemed experts here on the developments in China's approaches to global economic governance. And I'm delighted to have the opportunity to present to you on China's approach to ISDS reform and practice. As an important feature of modern international investment agreements, the ISDS Investor State Dispute Settlement Mechanism enables foreign investors to seek remedies in the face of a violation of related international investment agreements, which play a crucial role in the implementation of the substantive protection standards such as fair and equitable treatment and non-discrimination that have been consented to by the contracting parties. However, with the number of ISDS cases has increased and both developing and developed countries have been exposed to international arbitration, intensive debates on the legitimacy of the current ISDS regime are calling for reforms. Among others, sovereign concerns including impact on public policy and problems regarding inconsistency and incoherence in tribunal decisions are challenging the legitimacy of the current SDS regime. Debates on SDS reform at different spheres add to various options for reshaping the relevant mechanisms. And the ongoing global SDS reform dialogue provides valuable opportunities for China to actively engage in global economic governance and influence the development and transformation of global economic institutions and norms. Therefore, my presentation will dive into China's strategic approach to SDS reform, specifically within the context of its evolving practice of international investment agreements and its active involvement in the global SDS reform dialogue, especially at the UNSW Working Group 3. First, China's approach to SDS reform cannot be separated from its practice of international investment agreements and experience with ISDS. Over the past 4 decades, China has established an extensive network of international investment agreements, including 145 bilateral investment treaties and 24 treaties with investment provisions. However, Chinese bilateral investment treaties signed from the early 1980s to the late 1990s provide either no ISDS provisions at all or limit the dispute subject to ISDS arbitration to the amount of compensation for expropriation. Such situation starts to change since the bilateral investment treaty with Barbados in 1998, which expanded ISDS mechanism to all disputes concerning an investment between an investor and the host states. The shift to liberal ISDS provisions in China's treaty practice is primarily driven by the changing policies and increase of both inward and outward foreign investment. On the one hand, China has gradually changed its attitude towards international dispute resolution mechanism and acceded to the Exit Convention in 1993 and frequently referred to accept the Exit jurisprudence jurisdiction for all investment disputes in investment treaties. On the other hand, the ongoing global policy adopted since 2000 has contributed to a dramatic increase in Chinese outward investment. China's practice of investment treaties continue to evolve amid the global move to reformulated investment treaty regime to recalibrate the protection of foreign investor and policy space of host states. Since China's bilateral investment treaty with Canada in 2012, China has begun to adopt a more balanced approach with procedure prerequisites to discourage abuse of rights by foreign investors and incorporates exceptions and a variety of exclusions to constrain the application of the ISDS provisions. In the context of the ongoing discussions and reform options surrounding ISDS, as well as the exclusion of ISDS found in some recent investment treaties, China have adopted flexible and open approach in more recent treaties, including the RCEP and the EU-China Comprehensive Agreement on Investment. And these agreements provide only for state-to-state dispute settlement for now and defer the discussions on the inclusion of SDS to a later stage. However, it's important to note that China has not made any significant change to its overall stance on SDS in its investment treaty practice. This is not surprising since China has been playing a dual role of both the host and home country for a considerable amount of foreign direct investment. According to the World Investment Report, China remains the second largest recipient of foreign direct investment inflows and the third largest source of outward foreign investment in 2022. At the same time, China has perceived the SDS as a crucial tool for facilitating international investment flows and upholding the principles of the rule of law in the realm of international investment governance. Therefore, adopting a balanced approach to substantive international investment protection and SDS can effectively cater to China's interests in the global investment arena. On the other hand, while allowing for investors access to SDS has been a standard feature of China's investment treaties, China's experience with SDS cases have been relatively limited. To date, there have been 9 reported cases where foreign investors have filed claims against the Chinese government, with 8 of them relating to China's first generation bilateral investment treaties. In contrast, Chinese investors have shown growing interest in utilizing SDS mechanisms, as evidenced by 22 reported cases brought before the ICSID and other international arbitration forums. A closer look at China-related SDS arbitral awards shows that most of the arbitral awards were ruled in China's preference. This outcome may not necessarily lead to China's overall satisfaction with the SDS system, but it could potentially undermine China's motivation to implement significant changes or even replace the current system with an untested regime, such as the multilateral investment court system proposed by the EU and its member states. It remains to be seen whether China's attitude towards SDS will change in the future if it faces repeated loss in SDS proceedings. But given the dynamic nature of investment treaty practice and SDS reform, China has embraced a reformist approach toward SDS. In addition to China's recent treaty practice, its submission to the UNSW Working Group 3 further demonstrates its commitment to adapt and enhance the SDS system in a pragmatic and inclusive manner. In its UNSW submission, China shares several key issues with the current SDS mechanism, including the absence of an appropriate error correcting mechanism, lack of stability and predictability in arbitral awards, concerns about arbitrators' professionalism and independence, third-party fundings, and extensively long timeframes and high costs in investment arbitration proceedings. That said, China recognizes the inherent value of maintaining the SDS mechanism as it plays a crucial role in protecting the rights and interests of foreign investors and promoting transnational investment. In addition, China stresses the role of SDS in promoting the rule of law in international investment governance and preventing the politicization of investment disputes between foreign investors and host states. But based on the problems with the current SDS system, China supports a multilateral approach for improving the SDS mechanism, aligning with the government's commitment to multilateralism in global governance. In terms of the specific reform proposals, China supports the establishment of a permanent appellate mechanism, whilst China favors the option of retaining the right of the parties to appoint arbitrators at the first instance stage of arbitral proceedings in any reform proposals. I will come back to this later. In addition, China submits that it's necessary to enhance the rules governing arbitrators, establish a more effective investment conciliation mechanisms, incorporate pre-arbitration consultation procedures, and mandate transparency for third-party funding. By actively participating in the UNSW Working Group 3, China showcases its dedication to ensuring that the SDS system remains effective and relevant in the ever-changing landscape of international investment. Meanwhile, China is committed to actively participating in ongoing discussions and reforms with the goal of addressing the concerns and challenges related to ISDS through a multilateral approach. For the work conducted by UNSW Working Group 3, China recognizes the importance of considering pragmatic arrangements that cater to the diverse needs of parties involved, whilst highlighting the need of retaining a certain degree of procedure flexibility to ensure that important reform proposals are not overlooked. The third issue I'd like to talk here is the establishment of appellate mechanism. In the UNSW submission, China perceives a permanent appellate mechanism as an effective reform option for improving consistency, coherence, and predictability of SDS decisions. Actually, in the China-Australian Free Trade Agreement in 2015, it provides that parties should commence negotiations with a view to establishing an appellate mechanism to review awards rendered in investor state arbitration and subject the appeals on question of law. However, no substantial outcome emerged from the negotiations. The UNSW Working Group 3 have undertaken considerations of an appellate mechanism and published draft provisions on the functioning of an appellate mechanism, and also addresses issues relating to the implementation of an appellate mechanism, regardless of the form such mechanism might take, including an ad hoc appeal mechanism, a permanent standalone appellate body, or appeal mechanism as the second tier of a standing mechanism. In its submission to the UNSW Working Group 3, China supports the establishment of a permanent appellate mechanism that is governed by the multilateral rules, but it remains uncertain which specific form of appellate mechanism China would prefer. For example, a permanent standalone appellate body that would have the authority to hear all SDS cases, or appellate mechanism as a second tier in a multilateral court system. The idea of establishing appellate mechanism for addressing problems with investment arbitration is not new. The US investment treaties starting in 2004 include the possibility of a bilateral appellate body. The ICSID also considered the possibility of introducing an appellate facility in its discussion paper of 2004. However, this proposal was considered premature to many governments during the informal debates, and the recent amendments to the ICSID rules did not mention the establishment of an appeal facility. At UNSW Working Group 3 discussions, critics questions whether an appeal mechanism could effectively address concerns on the coherence and consistency of arbitral awards, given the diverse sources of laws governing the substantive investment protection standards and differences of languages in the texts. Even among states that are in favor of establishing an appellate mechanism, different countries have varying perspectives and preferences on many crucial aspects, including its scope, the effect, and also enforcement and the method for the establishment of an appellate mechanism. So far, China has not commented on the initial drafts on appellate mechanism by the UNSW working group. While China remains open and flexible to SDS reform options, it's advisable for China to carefully evaluate the different options to assess its compatibility with its own interests and objectives. In the negotiation with the EU on a comprehensive agreement on investment, China has not agreed to the EU's proposal for a multilateral investment court, which include full-time adjudicators and two-tier adjudication system to replace the current SDS system. Apart from the many controversies surrounding the multilateral investment court proposal, China's perspective differs from the EU's regarding party autonomy and the importance of preserving the right of disputing parties to appoint decision makers. China argues that the right of parties to appoint arbitrators at the first instance stage of investment arbitration is a widely accepted institutional arrangement that enhances the confidence of parties, particular investors, and should be maintained in any reform process. Nonetheless, some scholars suggest that China's position can still be compatible with significant reforms in terms of institutionalization by adopting the EU's open architecture approach, which allows for a certain degree of flexibility for countries like China to utilize only appeal mechanism. Another important treaty that deserves attention is the Regional Comprehensive Economic Partnership, the RCEP, which includes a built-in work program for discussions on SDS among contracting parties. The RCEP, and with structured framework, can provide a valuable platform for ongoing dialogue and cooperation on SDS reform, allowing China to foster collaboration and contribution to discussions on issues of mutual interests, including the possible appellate mechanism. The questions for Chinese government to deal with is how the proposed appellate mechanism can be designed to effectively address its concerns over the current SDS system, taking into account of possible hurdles, including the oppositions of other states and problems with the implementation of appellate mechanism per se. I think I will conclude my presentation for now, and I'm looking forward to the upcoming discussions. Once again, I'd like to thank colleagues from Tsinghua and UNSW for the efforts in organizing this conference. And it's unfortunate that I can only participate virtually via Zoom this time due to my current visit at ICSID, but hope for that there will be future occasions where I can meet and engage with Tsinghua colleagues in person. Thank you.
Thank you very much, Lou. And I'm sure you will agree that we have had a number of, or three, very interesting presentations from a wide variety of areas by people who have gone very deeply into the subject matter and have made it easy for us to understand what they were talking about, even though we may not be specialists in their area. So at the outset, we'll have question time now for probably 20-25 minutes, but I would like personally to ask several questions, one of each of the presenters to start, if that is considered to be appropriate. Firstly, I would like to address my first question to Professor Zhang Chenying. Unfortunately, I had to cut your presentation off, Chenying, and I apologize for that on timing issues. But I'm just wondering if you could speak a little more about what China is doing in practical terms to resolve the sorts of issues that you raised and which the other jurisdictions you outlined were addressing. So those issues of in relation to digital and fragmentation.
I will give a brief answer about the China's practice with the data flow. In summary, concerning the cross-border data flow, China adheres to the concept of security floor, constructing a tailored institutional framework for the regulation of important data and personal information outbound. It means that important data and the personal information, there are two paths about the protection and to the relative regulations. China's regulations for cross-border provision of personal information draw on experience from foreign legislation while enhancing the protection of individual rights. They offer various legitimate pathways for the cross-border flow of personal information. This benefits China with other economics and mainly focuses on the data outflow to prevent unauthorized access to data. To speak of this, we do have a standard contract for the data flow, and nowadays have 15 contracts get the permission from the authority to get the personal data outbound. And so to speak about the principles about the data flow, the first one is the to consider about the safety and the freedom. It do have the balance of these two strategies. Yeah, thank you, Professor Healey.
Thank you. My second question was to Professor Kun Fan, and I wondered if in the implementation of China's informal approach, do the parties start off on an equal footing, and how satisfied with the outcomes are the parties other than the parties who are pushing that informal approach?
Yeah, that's a great question. And I think that's probably a difficult one to sort of prove empirically, which is something I'm still hoping to find out. So part of this project is also to collect some empirical evidence and hoping to talk to those parties who were involved in those projects. Whether the parties is involved, I could give a first reaction to, like, in terms of whether they are having equal bargaining powers. And that's one one features of those in investor-state disputes. And I think that's one unique feature of this is this asymmetric nature of those investor-state disputes, right? And I think there's also some special feature in those BRI projects. So one aspect of the international investment law is to correct this asymmetric nature between like a private investor and state. Whereas in the context of BRI, I think the picture is more complex in the sense that the private investor are often led by China's state-owned enterprises. And sometimes it's not a clear distinction can be drawn from the private investor and the home state, right? Which is the presumption of those investment law is the distinction between the investor and the home state. But in the BRI context, I think the picture is even more nuanced. So by nature, there is some asymmetric nature of this. And this is particularly evident, I think, in those loan agreements, because usually lender have a bigger say. But on the other hand, even though Chinese lenders do have a bargaining power in the contracts, in the contract drafting. So we see a lot of those contracts do use Chinese law and CITEC arbitration. On the other hand, as I mentioned, there is still this practical difficulty, right? So they could have this legal resources, and we could say the Chinese state-owned enterprise have the resources to resort to arbitration. But if the sovereign state, let's say in one of the African states, default in those loan agreements, it's still very difficult for them to pursue arbitration, because even if you win an award, you may not be able to enforce it. So the asymmetry then, on the other hand, shifted to the hosting state in the sense of difficulty of enforceability. So it's a more complex nature. It's involving sort of dynamics in those negotiations of a contract. In the actual dispute, this bargaining power kind of shifted again. Whether this outcome are satisfactory, I think is a more difficult question. I don't have empirical evidence to support it. But in some of the cases where public records are available, for instance, where they could, if you enforce it in court, in arbitration, you may not to get the actual asset, but they have some renegotiated terms where you have a third-party injection of equity, right, or renegotiated terms. And there are some records where there are potential business opportunities. So that's potentially a win-win solution for both sides, right? So at least you get some of the fruit, you get some of the outcome. And for the other side, they could have compensation in kind rather than in actual financial compensation. So there's more flexibility, and there is at least a potential to create some win-win solutions. And I'm hoping to talk to some more participants in it about the, of their satisfaction, but I can just a quick reaction. There are more opportunities, I think, with informalist approach to find a win-win solution from both sides.
Okay, thank you.
And
It's Wei Wan.
I also want to ask several questions to each of the panelists. So you talked about the different approaches and regulatory priorities from three major jurisdictions, the US, EU, and China, and also different kind of focuses from them. You also talked about the bilateral and international efforts to negotiate different trade and other issues. So I wonder, can you elaborate a little bit about the prospects of the future of international cooperation because of the different kind of approaches and priorities from the major jurisdictions? What is the prospects of the future international cooperation on digital trade and data regulation? And perhaps, I think most importantly, the major points of disagreements between these major economies in such negotiations. So that's the question to Professor Zhang. So I'll ask a question to Quinn as well. My question to Quinn is also kind of a comment. As I understand what you're talking about based on the contracts, from the contracts perspective, you have this detailed dispute resolution clause, which provides different ways of settling disputes. My question actually relates to the foundation of your observation, which is about the cultural foundation. Now, if that is the driving force for China's approach, then have you thought about two kind of comparable situations? The first is that in many commercial contracts, you have very similar detailed dispute resolution clauses that set out different ways for settling disputes, including mediation, and perhaps even before mediation, you have this very detailed procedure for internal resolution of disputes by the officers and executives from both companies. And then you have mediation and other kind of non-litigant ways for settling disputes, and then you have arbitration and litigation. Now, another situation is where China's approach in international organizations such as the WTO, and China is still, at least seems to be very supportive of a enforceable WTO dispute settlement system. So my question is, if the culture is one of the foundations for China's approaches, how would you explain, similarities in the commercial contracts and also China's approaches in the WTO? So why the Belt and Road disputes are unique in this perspective? To Lu, I think the question is really relates to what Quen was saying about the effectiveness of arbitration and ISDS disputes. Can you elaborate a little bit more about how enforceable ISDS disputes decisions have been and could be, and whether that has been a major reason for China's approaches in ISDS or to ISDS disputes, or in using ISDS for certain disputes, and how you reflect on Quen's observation on China's preference for amicable or non-litigant approaches to dispute resolution in international commercial contracts and also investment, frankly, because that's mainly what the Belt and Road initiatives and projects about.
Thank you for Professor Joe, your question. And to, as my point of view, obviously that China, EU, and US, we do have different background on the culture and even the different concern about the fundamental for the personal data. But actually, we have three fundamental elements that every jurisdiction will concern about. The first is the national security. The second is the protection of personal information. The last one is a judicial enforcement jurisdiction. I think to narrow this 3 point of view, we have some things we can practice. The first one, that instead of the white list, we can have a black list, means the negative list. It's easier for the three jurisdictions to get the common sense or the common law in this under this kind of thinking. The second one is to emphasize the pre-regulation pressure, means that before get the permission for the data flow, this kind of consulting or the negotiation among these three nations is important and easier for the afterwards punishment or investigation. And we do have some practice, such as a contract, which I just mentioned, that we have 13 contracts to concern about the important information permission, and 15 contracts about the personal information permission to outbound. This kind of standard contract is easier for these three jurisdictions to get agreement in this area. Thank you.
Okay, and Professor Fan.
Yeah, thanks, Wei Huan. That's indeed a great question. Well, that's also always a challenge when you try to use a cultural approach. It's not a science. It's difficult to prove, okay, black and white, this is a cultural element. So I'm not claiming that cultural is the primary driving force, but I think you could use it as explanatory, right? To what I agree with you that it's not uniquely Chinese that in the contract they have those multi-tier dispute resolution clauses. Sometimes in those investment treaty also they have those, usually during the cooling off period, right, where parties can use consultation and other forms of settlement. But I think there's something unique in the BRI context is that a lot of BRI projects are long-term infrastructure disputes, right? So it really have a very long timeline. And indeed, there were some empirical survey done by this research institute that I mentioned earlier that they interviewed some Chinese enterprises who mentioned specifically that in those infrastructure disputes, they would be concerned of initiating, even though they have also arbitration clause as an option, but if they use an arbitration, then there will be this relational damage, especially it's very competitive in the infrastructure dispute. So even if they win this case, they might lose future contracts. So I think that's one important consideration in the BRI context. And another uniqueness in the BRI context is the overall discourse of BRI that we emphasize is it's an open texture, right? Different from the Europe model, which is more club-based, right? Whereas the Chinese BRI is very flexible in the BRI primary agreement. It's mostly based on the memorandum of understanding, flexible partnership-based approach, pragmatism, and some describe this as a partnership-based approach. So I think that also have maybe some cultural element to it, given this historical emphasis on relationship. And Hofstede have done some cultural dimensions, which based on a number of comparative data, so long-term orientation for China is also scored especially high compared to its counterpart in the US and EU. So I think this relational mode, cultural can be one explanation, but there are other important considerations, practical considerations, as I mentioned. So it's a pragmatism, right? So, well, cultural relationship is one aspect, but also to what extent you can actually get this interest, right? So I think the BRI unique context means that interest-based approach is probably more appropriate than the right-based approach, right? So the interest in the long term in the broader BRI picture may be more important than pursuing this legal right in this particular case. But I wanted to add also qualification that this attitude might be changing, right? So it's developed hand in hand with formalism, especially in commercial dispute. We do see Chinese enterprises are getting more aggressive and they do defend their rights. So I might, if I could, sort of follow up on this, more of a discussion and probably also come back to Lu's point on China's approach to ISDS. So I mentioned, and Lu also mentioned that in the public record, there's still a very small amount of disputes that China either involved as a respondent or filed by the Chinese investor. But we can see the high percentage of those cases are actually filed after 2020. Right. And in the very first investor state arbitration against China filed by the Malaysian investor, again, China uses the informalist approach, even though indeed in the China-Malaysian BIT, there's no exit provision. So China potentially have a chance of successfully challenge arbitrator's jurisdiction. But instead of raising a jurisdictional challenge, it pursued a settlement of this case. So this case actually withdrawn pursuant to the settlement. But later, China did successfully defend it in at least 2 cases filed against China, right? And we also see that use big Chinese law firm and big foreign law firms engage in those cases. So do we see actually a change in attitude, right? Maybe it's early indication that attitude is changing. So that's what I meant is that you have formalism, informalism, but also there are some signs China is also taking a more legalized position by institutional building as well. So it's a blending of order. Informalism still play a very important role, but that goes hand in hand with other legalized process.
So I would like the other participants to join me in thanking the speakers for their thoughtful and interesting presentations. Clearly, you're all engaged very deeply in these areas of work, and we look forward to seeing some more scholarship from you, publications that we can read, setting out your views. So thank you very much, and that will be the end of this session. And I look forward to joining the following session. I believe that the participants in Beijing are going to lunch. Half your luck, to use an Australian phrase. Thank you, everyone.